Hi, everyone. Thank you so much for joining us today. My name is Brianne Hollenstergar. I am currently a visiting assistant professor at the University of Montana, Alexander Blewett III School of Law, and will begin as an assistant professor in the fall. And I'm also a former Civil Justice and Innovations Fellow at the Rhode Center, Deborah Rhode Center for the Legal Profession at Stanford Law School, and currently a non-resident fellow there. So today's webinar is the third in our four-part series, which is inspired by the Rethinking the Lawyers Monopoly book, which was edited by David and Nora Freeman Engstrom, the co-directors of the Rhode Center and Stanford Law School professors. The book is very accessible. It is available for free online, so we definitely encourage you to check it out. We'll put a link in the chat so that you can access that. So again, this is the third of four webinars that we've hosted. The first in the series explored frameworks that folks can use to guide how we think about the changing market for legal services. And the second, we talked more about what's happening on the ground, and we canvassed a subset of existing reforms in states that are kind of being implemented in states today. And this is the third panel in our series, and I'm very excited to moderate this discussion. And we are going to be focusing on applying a comparative lens. So looking at lessons that can be learned from other industries, other jurisdictions, other places regarding restrictions and loosening restrictions on the legal services market and responding to the rise of new providers, new technologies that are intended to deliver quality legal services. So we have a wonderful group of panelists today. I will briefly introduce them before we kick off the discussion in earnest. So first we have Rebecca Hall Allensworth. She is the David Daniels Allen Distinguished Chair of Law at Vanderbilt University School of Law. We have Allison Hoffman, the William Mall Measy Professor of Law and Health Sciences at the University of Pennsylvania Carey Law School. Juliet Oliver is the co-founder and managing director of Passmore and Oliver Partners and was formerly deputy chief executive and general counsel to the Solicitors Regulation Authority in the United Kingdom. And finally, we have Lauren Van Schilfgaard. She is an assistant professor of law at the UCLA School of Law as a graduate of the UCLA School of Law. Go Bruins. So each of you brings a very unique perspective to the conversation on the lawyer's monopoly and legal regulation more generally. So I'll first ask each of you kind of one question to kick the conversation off, and then we'll open it up to the floor. But Lauren, if we can start with you. So your chapter in the Lawyer's Monopoly book, which is wonderful, by the way, discusses tribal lay advocates. And so first of all, I just love for you to discuss a little bit more about who these providers are and how they fit within the lawyer regulation framework, both compared kind of to the broader framework in the United States, but also when you situate them within tribal law more kind of specifically.
Thank you. Thank you so much for having me. I love when books like this intentionally make space for tribes and tribal courts. It seems obvious, but it's a move that I nevertheless want to celebrate. So tribal lay advocates are effectively non-law school graduates, non-state barred representatives within a tribal court setting. So they are effectively a defense counsel or a defending counsel, but without a law school degree, sometimes without even a bachelor's degree. But within the tribal court, I think it's important to position what exactly is happening in tribal courts. Tribes have, I think, pre-contact, the tribal government as we know it was effectively just exclusively a judiciary. The primary functions that we might relate to a government generally didn't include the executive or the legislative as we understand them today, but they definitely included this dispute resolution mechanism. Contact was disruptive in many ways that we don't have time to go into today, but it disrupted the tribal court. It means today the tribal courts that survived, and that includes about 300 operational tribal courts as we understand it, a whole discussion about why we don't really have a solid understanding on how many tribal courts are out there. But part of it is because tribes are sovereign, both from the United States, both from the state governments, but also from each other. They are autonomous entities. But they have been heavily pressured by the federal government to look, sound, feel very similar to an Anglo or American judicial system. This includes being pressured to adopt the adversarial system, in which we have litigants competing with each other as a truth-seeking methodology. And it means that there are pressures to include things like defendants' rights, which are really cognizable in a certain system that includes a centralized oppressive government, which may or may not be reflective of what a tribe is necessarily doing. All that is to say, what is the tribal court today? It looks a lot like an American court with a judge sitting up on a dais and overseeing an adversarial system. And so the need for an advocate is really comparable to a non-tribal system. However, there's a couple of key differences that I think are worth noting for why the lay advocate in a tribal court is uniquely situated. This includes the 1968 Indian Civil Rights Act, federal law, part of the civil rights movement, but in many ways was very oppressive to tribal courts. This included pressures to, again, further adopt the adversarial system, but most noteworthy, it includes a sentencing limitation. That is, tribes were effectively demoted to misdemeanor status. They can only ever incarcerate an offender for up to a year for any offense, including very serious offenses like murder, rape, child abuse. And so that immediately put tribes in a particular sort of defensive posture. There's been some modifications to that in the 21st century, but they're still very slowly being implemented. So for the majority of tribal courts, they're operating in this misdemeanor status. But the flip side is that a tribe retains the sovereign authority to do pretty much everything else, regulate who appears before the tribal court. So tribes have their own bar associations, they have their own criteria for who can appear. The other big component to think of is, I think the whole premise that brings all of us together is that many, if not all, court systems are under a budgetary constraint, right? If money was no object, then we could be a lot more creative about access to justice, but money is very much a concern. It unfortunately is triply true for tribes. Not only do tribes face the normal budgetary constraints like all courts, but they have limited tax access. That is, because of the trust status of tribal lands, no property tax. Because states largely enjoy concurrent or simultaneous taxation authority for sales, no sales tax for tribes. Because their states similarly are exercising that concurrent authority for income tax, no income tax. So all of the normal lines where a court derives its revenue are deprived for tribes. So tribes are under very serious constraint. All of these like federal constrictions on tribal courts, plus the budgetary constraints, plus a historical tradition of dispute resolution has created a really unique framework that is very accommodating for a lay advocate.
Wonderful. Thank you so much, Lauren. And I think just one quick follow-up. I think
Yeah,
one thing that your article or that your article that your chapter really presents in such a compelling way is kind of the way that tribal codes kind of formalize the role of the tribal lay advocate and formalize like what they can do. So I think just to add a little bit of context for our readers, could you provide potentially some examples of how tribal lay advocates are representing people in tribal courts today?
absolutely. So the code component is interesting all by itself. In part, there's not a whole lot of positive law or tribal code that's changing dramatically. Sort of the sheer volume of code that exists today is 10 times what it was 20 years ago for reasons including because it's not a traditional form of organization for tribes, but it's also the piece of tribal law that's most publicly accessible. So I looked at it as just a snapshot of what's going on with tribes. And in fact, there's a lot going on in the tribal code in relation to tribal advocates. So I was looking at just like, what do tribes have to say about this? They have a lot to say. I defined a lay advocate as a non-law school graduate and a non-state bar attorney, two negative frameworks. That is not how tribes describe lay advocates. Rather, their descriptions are all positive criteria. The criteria ranges pretty significantly, but it's clear that they have a regulatory perspective on who lay advocates are and to what extent they are accountable both to their clients as well as to the tribe. Ways that I think have a lot to contribute to an overall discussion about access to justice. This criteria includes basic code of competence, candor, a general trust obligation both to their client and to the tribe, which I think is really interesting and implemented in a variety of ways, including ways that deviate sometimes meaningfully from the ABA code of conduct. It includes criteria that the lay advocate have some kind of pre-existing connection to the tribe, such as they are a tribal member or maybe even just an Indian, and that status will prioritize their eligibility over others, such that non-Indians or other non-members do have to be a state barred attorney in order to appear before the tribal court. And then others include a requirement about familiarity with tribal law. This can include familiarity with the written tribal code, but I think much more interestingly, familiarity with tribal custom and tradition, areas of law that are very deep and traditional for tribes, but are not written down and therefore require being enmeshed within a community, familiar with the historical customs as well as the contemporary norms, but also with the people. One of the things I really love about tribal courts that's a big deviation from a non-tribal court is the extent of conflict of interest. Prior familiarity or even relations with a person is often disqualifying in a non-tribal setting. In a tribal setting, it's considered a requirement. It is our familiarity, our kinship, from which our obligations derive. And so therefore, strangers is a very awkward way to conduct dispute resolution in ways that tribes, we really thrive and depend on these kinships. And you see that reflected in the code regarding the regulation of lay advocates.
Thanks so much, Lauren. I encourage everyone to read The Lawyer's Monopoly, but your chapter in particular, I think, offers such an eye-opening take on what a system that is not so rooted in kind of the European adversarial system can look like, and the roles that people can play within that system. Juliet, let's turn to you. So, Juliet, let's talk a little bit more about about legal regulation in England and Wales. So, alternative business structures, or ABSs, they've been authorized there for some time now. And how I'd like you to speak a little bit about how the change to the lawyer's monopoly came about, and then what was the traditional bar's kind of reaction to this loosening of who can practice law, who can provide legal services.
Brilliant. Yes, thank you. And thanks for having me to join you and join a very distinguished panel of academics and professors, first allowing me to come as a Brit, and also as a regulator, and then as a consultant, and with the England and Wales framework, which is kind of quite different, as you know. So I think really we've seen very significant and quite sort of wide sweeping changes to the regulatory framework over the past sort of 20 odd years, with sort of modernising and liberalising of the framework in England and Wales. And, key milestone, I think, for me, and one to sort of, which is it's actually quite an interesting read. It's a report from the Office of Fair Trading, over here, which was looking at competition across the professions. It was published in 2001, and it looked at the legal profession, but also other professions. That was then followed by a very significant review called the Clementi Review. It was a review carried out by David Clementi in 2004, and that looked specifically looking at the legal sector on how to promote competition, innovation, and an efficient, effective, and independent legal sector in England and Wales. And that led on directly to the ABS changes, amongst others, in the Legal Services Act 2007. But if you go back to the Office of Fair Trading report, their starting premise was that restrictions on entry, practice requirements, and restrictions on supply to professional services will tend to drive up costs and prices, limit access and choice, inhibit innovation, and all of that's the ultimate detriment of the public. They may be justified if they serve economic progress or if they serve the interests of consumers, but the report raised concerns that, particularly where the restrictions are imposed by professions regulating themselves, there's no guarantee that they wouldn't go further than necessary, that they'd sort of fail to strike the right balance between the consumer benefits that you get from competition and the consumer benefits you get from sort of protective safeguards. So just look at some of the issues they looked at in particular in law. Many of you may know, but we've never in England or Wales had the equivalent of the unauthorised practice of law here. But there had been a statutory monopoly over certain activities, certain legal activities for some time. So, for example, conveyancing, handling real property, and litigation being reserved to solicitors. Advocacy for barristers. As you know, we've got a split profession over here. And all of that was combined with protection of title, so barriers to entry for those professions and, protections against people using those titles. At the time of the OFT report, those had started to be eroded by the introduction of different kinds of lawyers. So, for example, you could have licensed conveyancers, people who are licensed just specifically to do that kind of activity. But the Legal Services Act, when it came in, provided for effectively competition amongst a set of approved regulators. So it defined a list of reserved activities and said that these could be carried on by anybody authorised by any one of those regulators. So it effectively provided a market amongst the regulators themselves. The Act established regulatory independence of those approved regulators from the representative and commercial interests of the professional bodies and set up a legal services board, an oversight regulator to kind of safeguard that independence, because, as I mentioned, that independence was considered necessary to bake it in to make sure that regulation didn't go further than it needed to be. Prior to the Act, there'd also been a ban on multidisciplinary practices with rules preventing fee sharing and the like. And this was an area that 2001 report focused on particularly, noting the potential for increased diversity of choice for consumers and potentials for kind of economies of scale and delivery if you could allow professions to provide services alongside each other within the same sort of business. As you know, and as you mentioned, the Legal Services Act particularly allowed for almost full non-lawyer ownership and management of law firms, the ABS regime, the alternative business structure regime. The only requirement in the Act is that there needs to be at least one lawyer manager within the firm. So really a very significant liberalising provisions there. And the SRA, the Solicitors Regulation where I worked, introduced its licensing regime in 2011. Other legal regulators, such as the Council for Licensed Conveyancers, the Bar Standards Board, have done so too. Last point to mention before moving on to the reaction to all this significant change is that actually following the Act, so following the introduction of ABS, there was still significant restrictions on solicitors because they were still subject to rules that were imposed by the regulator that prevented them from acting for third parties from outside of regulated firms, regulated businesses. So employed solicitors could only carry on work for their employers, so a sort of pure in-house function. The idea that you could be a solicitor and provide services to third parties from an unregulated business was not something that was permitted. This became out of step with an increasingly liberal and diverse market. There was increasing pressure for change on that. and many organizations and solicitors providing workarounds to meet the sort of demands from consumers and clients for a range of services from a range of different businesses. And so people would sort of want to employ skilled lawyers and call them non-practicing solicitors in run unregulated businesses and firms. So what then changed in 2019 was outside of certain statutory limitations for reserved activities, those restrictions were removed completely. So now solicitors are allowed to practice in unregulated businesses, set up on their own as freelancers, can work outside of a regulated firm. So the reactions from the traditional bar. The ABS changes were, to say the least, contentious. So during the passage of the bill, there were predictions of catastrophe for the market. There were warnings this would be the end of the solicitor's profession. We were all going to kind of, end up, I don't know, in some kind of pit of despond and despair, and it was all going to go to hell in a handbasket. Breaking that down, I think there were a few different sort of red buttons that people were sort of, the issues that people were concerned about. I think the first, there was concern about what would happen when profit entered the equation. There was seemingly a sort of rose-tinted worldview that lawyers are motivated only by a sense of occasion and were not running businesses or seeking profit. So that when you brought non-lawyers in, all of a sudden there would be sort of commercialization of justice, a race to the bottom with the idea, and we had this phrase here, Tesco law, the idea, Tesco being a big global supermarket chain, the idea that law would be sold alongside groceries at the supermarket and quality would be down in the, there'd be a race to bottom there. The impact of competition was a common theme. So some felt that competition might provide opportunities to increase access to justice, access to the profession, but others felt that new entrants would kind of gobble up smaller traditional firms. And there were a lot of voices saying, if you're going to do this, you have to have a level playing field and rules and restrictions must sort of level out the playing field. Ironically, these were the traditional partnerships which had benefited from the unlevel playing field beforehand, but that was a real sort of concern. There was also a concern about ABS being high risk, because there was a view that was quite openly expressed that non-lawyers would inherently be unethical, that professional independence of solicitors would be fatally compromised through either undue influence from non-lawyers or through conflicts of interest. And there were also concerns about the potential complexity of the structures and businesses that could now potentially be authorised. So this would open up a range of different structures and types of business. So with concerns about how is this going to work, how would they be governed, how would they be regulated. So, I know we're going to come on a little bit up to the impacts of the changes, so I won't go into too much of it now, but I think, spoiler alert, the sky didn't fall in on anybody's head. The changes to the market, they started quite slowly with quite small numbers. They weren't radical. It built up gradually. There had originally been a fear from some particularly larger traditional firms about the stigma of becoming an ABS, how this would be viewed by people. If they had international associations or clients, would international jurisdictions think that this was something sort of to be concerned about? But the numbers have steadily increased. The latest published SRA figures from 23-24, there are 1,257 ABS, 14% of the legal market for firms here. And that adoption has been across the market, from the smallest firms to the largest firms, from incumbents converting to new entrants. And I know we're going to come back to the changes to the shape of the market, risks, benefits. So I'll pause there just to give you that little sort of thumbnail sketch.
I think that thumbnail sketch is a wonderful preview. And also just, everything you said sounds so much in what is happening in the United States right now, with a recognition that perhaps self-regulating professions may not regulate in the public interest, and a growing awareness that some structural changes are necessary to ensure that consumers are receiving the best quality services and accessible services. So thank you so much. Let's turn to Rebecca. So Rebecca, you have a chapter in the Lawyers Monopoly book, which is wonderful. I've sent it to many students who are interested in the disciplinary system. But you've also written at length in your own book, The Licensing Racket, which I also highly recommend. It's wonderful. You have discussed professional licensure in other industries, in addition to the legal profession. So my first question to you is the lawyer's monopoly unique, or are other industries just as protective of their own professional scope? And are these protective instincts kind of reasonable and justified, or do they reflect more of self-interest on the part of the self-regulating or the licensing body and licensing profession?
Yeah, and before I begin, I just want to thank you guys for inviting me to this and including me in this. I really had a wonderful time at the conference and writing the chapter, and also now doing this. So thank you for including me. Um, yes, I wrote this book called The Licensing Racket, and the idea was to write a book about all professional licensing, the regulatory system that we use to regulate what amounts to the biggest, most important labor regulatory institution we have, which is the professional license. It covers 20% of American workers. There's about 1 million lawyers and 1 million doctors out there, and many, many, many millions of other professions that have to have this state certification, this state imprimatur to practice their trade lawfully at all. And one thing that I found really interesting and understudied was the institutions that we use to implement this regulation. It is this state licensing board that is usually made up of volunteers from the profession itself. Often there's a couple of lay members who are not from the profession, but they almost never outnumber the professional members on the board. And they are busy practicing professionals with their own practices in medicine and in law that take a few days out of the year to kind of moonlight as their own regulators. So this is a very self-regulatory system. And at least outside of law, it's nominally a state agency. It's created by a state legislature. But there's very little to it that I think amounts to actual state decision making. It really truly is like handing over the decisions about entry into the professions and discipline over to what functions as a professional association. So to answer your question, this issue that we have in law of self-regulation and the effects that it has are very similar to those in other professions, but there are a few differences, and it's kind of worth noting them. Um, Let me begin by saying that my methodology for this book was to actually start showing up to licensing board meetings. I wanted to know what's really going on. I wanted to kind of look under the hood there. It wasn't enough to just read the statutes online to look at, who's making these decisions. I wanted to see how they made these decisions in real time, how they thought about themselves. I wanted to interview them. I really wanted to deeply understand these boards, their motives, and how they viewed themselves. So, in my state, there's a sunshine law that says that I have a right to be, any person in the public has a right to be at these licensing board meetings. Well, nominally, this was true for one of the law boards in my state, which was the disciplinary one. It wasn't true even nominally for the one about the entry, the bar examiners board. And so I couldn't attend any of their meetings. And then I did go to a meeting of the disciplinary board, and they said, "Oh, welcome. Thank you, member of the public, Professor Allensworth of Vanderbilt. We have her here." They even introduced me at the beginning of the meeting, sitting in the audience. Um, okay, and I call this meeting to order. And now we will go into executive session, and I'm afraid, Professor Allensworth, you need to step out. And so that was really what I saw of the licensing board work in law. So this, I think, has two implications for what I'm about to say. One, that I know less about the inner workings and the self sort of perception and the what the boards are doing and the way that they think about it and the way they talk about it when they're doing their work. I know less about law than I do about the other professions, ironically, even though I'm a lawyer. And the other thing is, we know it's even less transparent. And so a lot of the problems that I saw in the other professions are likely to be even worse in law. So, what do we know happens behind this curtain in the professions I was able to observe, and probably happens and maybe to a greater degree in law? Well, we know that members of the profession have an interest in keeping their services scarce. And this could be, you could sort of furnish an economic explanation for this. You could say that they want to keep their rates high, and the more kinds of people and the more people that are allowed to provide services, the more competition will drive down those rates. I saw I saw a little bit of evidence of people making those kinds of arguments, but more often that argument was framed as a question of prestige and sometimes equity. It was this sort of the way that we would be regarded if we just let anybody do our profession that seemed to matter more to the self-regulators than the kind of the financial dollars and cents. Now, that is to say, that's what they were talking about. It's not clear that they weren't also really motivated by the financial um, um, rewards that would come from keeping entry really limited. So in other professions, this looks like a long professional education, a difficult exam. Does that sound familiar? In the States, we have a graduate degree for a lawyer, which is not typical of other countries, which amounts to 2 more years of education than other countries. We have a very difficult bar exam, sometimes really difficult in some states. This is very controversial, and it's assumed and sort of known, and in some cases empirically supported, that these barriers to entry really create a scarcity of legal representation. And then you've got the access to justice problem that comes from there being too few people who are qualified to give legal help. It's too expensive, which is bad in and of itself. But I think in the case of legal services, it ends up being not just too expensive, but out of reach. And so people have to represent themselves or forego, bringing a legal case in the first place. So I lay some of the blame of this problem, this too much red tape problem, on the structure of self-regulation and these boards, which are made up mostly of lawyers, just like in other professions. Um, Another way in which we see the self-regulation play out in both law and other professions is this idea of unlicensed practice. So the professions that I was able to observe in this sort of rulemaking entry um, um, modes and also discipline were very interested in going after unlicensed practice. So I'll give you a few stats from some different professions, and maybe I'll have a moment to talk a little bit about what this looks like in law, likely. So I saw the alarm system installers do their discipline against unlicensed practice, and they had 2/3 of their complaints that came through the door were from consumers about, I guess, predatory or incompetent alarm system installers. The board took action in 17% of those cases of consumer harm. But when a licensee complained about unlicensed practice, somebody installing an alarm system without a license, they took action in 60%. So it's a difference between 17 and 60%. They were 10 times more likely to discipline in unlicensed than in safety issues. In auctioneers, I saw something similar. They dismissed 80% of consumer complaints. And these were complaints alleging the things that if you asked an auctioneer, why do you need licensing for your profession? They would tell you shill bidding, misrepresentation of items, absconding with funds. These complaints would come through the door from consumers for those things, and they would dismiss almost all of them. So what does this look like in law? Well, we know that the defining the contours of what is legal representation and making sure that only lawyers can do that is kind of an obsession with state bars and with state professional regulators. They want to keep it capacious and they want to keep it vague. And I say this like they're mustache twirling villains who are trying to cartelize, their profession. And that was not at all my experience with the professionals that I got to know who were on licensing boards in other professions. And I have no expectation that it would be also for lawyers. But there is this conflict of interest that inherently comes from being a licensed professional, regulating your own profession, that pushes us towards more and more of these barriers to entry and to be as capacious as we can with the definition of what is law and as restrictive about who can do it. So I also have a whole set of insights about how this looks not in the barriers to entry side, but also how it looks in the disciplinary side. That was a real surprise in my research. I'll save that for a little bit later, but that's kind of the compare contrast that I'm able to derive between the professions I was able to observe with a front row seat and the profession my own that I had to see a little bit indirectly.
Thank you so much, Rebecca. It's so valuable to be able to kind of step out of the legal profession bubble that I know I so often find myself in, and to realize that these are universal, well, maybe not universal, but at least widespread issues that the legal profession simply kind of reflects. Allison, finally to you. So your chapter in Rethinking the Lawyers Monopoly focuses primarily on physicians. And so medicine kind of seems to be ahead of the game when it comes to diversifying providers. We have PAs, we have NPs, But can you talk to us a little bit more about how kind of physicians developed this kind of monopoly on the practice, and kind of what you see as some of the long tail effects of that monopoly?
Sure. So, it's interesting to compare the two. Looking at the world of medicine, I think offers a cautionary tale, although there are bright moments or things to pick out as well. So as I read about the medical profession and what the law might learn about from the medical profession, I really tell a cautionary tale for the law. My chapter I call How Power Undermined the Medical Profession. And so it's about how, as physicians really built up their own physician monopoly, how that's created lots of problems down the line, and really has helped to enable and facilitate the corporatization and financialization that we're seeing in medicine now. Has harmed practitioners, has harmed doctors, and has harmed patients as well. And so the question you ask is about how did that all start? And it started really in a lot of the same ways that law did. Physicians created a monopoly over the practice of medicine. They did this in a number of ways throughout the 20th century, and Rebecca was talking about some of the tools of that. And so if you rewind to the early part of this period, you see the medical profession, and I'm talking really about doctors here, working through professional associations like the American Medical Association to limit supply and keep prices high, kind of keep a barrier on who could practice medicine. And they work to develop modern licensure laws in the name of protecting the public through things like the kinds of licensure boards that Rebecca was talking about. So saying they were protecting the public from quackery, but also limiting supply. They also contracted supply by limiting the spots in medical schools for training in the early 1900s through justifying a justification that was based on more scientific learning in medicine. They did things like shuttering most of the historically Black medical colleges, and we saw a decline in women who were admitted to these schools, who up to that point had actually begun to study medicine in larger numbers. And so there was this decrease in supply. And then the second thing that happened was that the profession allowed others to provide care, but did so in very constrained ways based on what are called scope of practice laws. And so people like nurse practitioners and others were called physician extenders. They were called that because they were seen as kind of secondary to doctors and under their supervision. And these laws limited what they could do, and they limited more narrowly than what they're actually trained to do or capable to do. And then the third thing that we saw was that the profession advanced state prohibitions against the corporate practice of medicine. And so these were rules that developed either through the common law or through statutes that prohibited corporate control over medicine or the practice of medicine by non-physicians. These have waned over time, which is interesting to think about, juxtaposed to the legal profession, where they still are largely in place. So if you look at this buildup of a monopoly in the medical space, one thing that's interesting and one positive thing I'll talk about, and then I could talk more about the negative results that have resulted, as well, is that we've seen a loosening of the scope of practice laws. We've seen states allowing non-doctor practitioners to do more. And some of this was already happening before the pandemic, but was really accelerated during the pandemic when we desperately needed primary care providers. And so people like nurses and nurse practitioners and pharmacists and others were allowed to do more in line with their training and their skills, not based on these artificial external limitations. Evidence showed before that and increasingly showed throughout that period that loosening restrictions in these laws enhances access and doesn't depress quality. So that's great, and it really shows that more people can do the kinds of things that we sometimes think are the domain of just the lawyers or just the doctors. But it's a mixed picture of medicine as well because it came late in the game. Nurses are leaving the profession. We're seeing really acute shortages in the kinds of practitioners who could have filled this space. And it's not clear if, even as you start to loosen these laws now, if it'll reverse this kind of trend with all of the larger changes happen in medicine, including the more complicated pieces, the corporatization. And with corporatization, some of the outside investors take advantage of these loosening scope of practice laws in ways that might not be beneficial in the long run. So I could talk about that more as we get into discussion, but I'll just flag it now for further discussion.
Thanks so much, Allison. I think your chapter in particular, I think, serves as a bit of a cautionary tale, but kind of just maybe valuable information for especially reformers to kind of have in mind as we kind of enter this new era of redefining what the legal profession really looks like. Um, so just for everyone attending, we're going to save about 10 minutes for questions at the end of our hour. But I'd like to just open up the next question to the panelists, and hopefully each of you can kind of speak to it as, you know, kind of your experience and expertise dictates. But obviously, you know, we see consumer harm, protection of the public as the stated goal of regulating professions, licensure. But of course, there are other objectives, and I think Juliet, you spoke to this in particular, saying, you know, the UK and Wales specifically recognized that competition was an objective that potentially, you know, licensing and the regulatory system should serve. You can also talk about innovation, accessibility. So I'd love for each of you to speak a bit about how professional monopolies have supported or kind of hindered regulatory objectives, consumer harm, or these other kind of more peripheral regulatory objectives. And then what have the impacts of certain reforms or certain structural kind of aspects of regulation that loosen that monopoly and allow individuals other than, you know, the physician, the attorney, to provide services? So I think whoever wants to take it away first. Rebecca, Juliet, go ahead.
Well, I was going to say, shall I talk about, you know, how the changes breaking open that monopoly have kind of result, you know, what we've seen as a result, because that might be interesting. And so first of all, you know, you're absolutely right. The whole point about the change was to recognize that there was a range of benefits that regulatory frameworks could achieve. Consumer protection is one of them, but it needs to be balanced against some of the others. But looking at consumer protection and that sort of those sort of dire warnings that everything was going to go to hell in a handbasket. I mean, there's been no evidence of any greater risk presented by ABS or greater harms caused by ABS since they came in now 15 years ago. We've had some recent high profile events and scandals in the kind of in the England and Wales sort of market, some large firm failures associated with sort of some big alleged frauds over the last couple of years, and also some problems with sort of rapid growth in sort of large firms due to sort of certain business models, etc. The SRA is looking at how it supervises the changing dynamics and risks arising from the changes in the market, and, you know, the framework kind of afresh. But I think what's really important is it's far from evident that liberalisation of the market is at the heart of any of those issues. And actually, of those recent failures, one of the largest was Axiom Inc. It's been sort of high profile here. I don't know if you've heard of it. 65 million alleged fraud took place in a traditional law firm, appears to have been perpetrated by a solicitor. So really important to kind of keep that at kind of, you know, in frame. But as you say, other objectives that the changes were trying to achieve: diversity and strength of a market. So, you know, as I said, we've seen different business structures, different delivery models, different services, the rise of sort of technology in the market, AI litigation services with some firms authorized very recently, which are real consumer-facing AI-only services, and the growth of alternative providers. A trend in terms of private equity-backed consolidation in mid-market consumer law, so particularly in areas such as personal injury and family law, with the latest figures showing that around 31% of M&A transactions in the last year, which is a big spike, it's been year on year, were PE-backed. But whilst we've got consolidation in the market and maybe a reduction in the numbers of firms, the numbers of solicitors has increased year on year on year. And of course, now non-solicitors can be rewarded by partner, member or director status in firms, have a direct stake in the business. So sort of diversity within firms, diversity in the market. In terms of innovation, we've had bits of research here. One from just over 10 years ago, which showed that ABS were up to 15% more likely to introduce new legal services and to innovate across all areas of the business. So organizational innovation, service innovation, marketing, strategic. higher levels of investment in R&D, higher levels of staff engagement in and external involvement in innovation and sort of partnership, external partnerships. And then more recently in 2023, we've had some further research and report on technology and innovation, which showed that ABS were more likely to be using up to 7 of a list of 13 different technologies that they asked a whole bunch of firms about, which include, live chats, video conferencing, blockchain, and some remote services, things that can kind of improve access to justice in particular. And we're seeing a real driver towards that here in the regulatory framework. I just finished by saying, I think what this all has demonstrated is, letting 1,000 flowers bloom provides the opportunities for opening up consumer choice and access to justice. Proving direct impacts on access to justice as opposed to loads of individual examples is quite hard. We don't have quantitative stats on that here. And access to justice remains an issue, a sticky issue, and one that, regulators, law societies in England and Wales are focused on with kind of levels of unmet need. But, we're really seeing that investment in technology and the opportunities for different service delivery is, driving that innovation and driving sort of new types of services.
Thank you so much, Juliet. Rebecca, something that Juliet said kind of reminded me of your chapter in that, we kind of need to be mindful of fraud that is taking place or that is being perpetuated by members of the profession itself. So I'll kick it to you next to kind of answer this question and offer your insights.
Yeah, so the theme of this part of the discussion is like what have the professionals done in response to attempts at reform? And I think one thing that I encountered over and over again was that the professions are very, very reluctant to give up the thing that I think is the root of most of these problems, which is that self-regulatory structure. And what I was surprised to learn, the red tape and the barriers to entry was something that I was expecting, but what I was surprised to learn is that part of what comes along with this self-regulation is a very inappropriately forgiving disciplinary system. And this is something that I think the professions don't view it that the way. They don't view it like fraud in that I think the word that you used is apt in a lot of context. They don't see it that way. To them, the second chances that they give to very bad providers have an internal logic having to do with second chances and forgiveness and often drug and alcohol abuse treatment and getting the bad provider. And I say the word bad not lightly, like we're talking about not like somebody who's not that competent, but maybe somebody who has, in the case of doctors, been selling scripts for cash for opioids that couldn't possibly be for treatment of pain. We're talking about sex abuse of patients. In the case of lawyers, we're talking about using client funds for gambling, other examples of stealing from clients, coercing sex out of vulnerable clients for services, and things that just are sort of beyond what any of us would expect would result in some very harsh discipline, often get kind of slaps on the wrist. And I don't think that the professionals running their own disciplinary systems see themselves clearly in what they're doing. I think they see it as, like I said, this person's a trained professional. They have a whole set of people that they are serving. We don't want to worsen the access to justice problem, or in the case of other professions, the access to care problem. That becomes paramount when we're talking about discipline, where it was very unimportant when we were talking about the red tape on that other side. And I think one of the things that I found most interesting, one of the effects of the self-regulatory system resisting anything else and resulting in this too light disciplinary system is the effect it had on vulnerable clients and patients. So in the case of medicine and the health professions, if you had discipline that went on your record but was not a license revocation, which is mostly what I saw, even for some of these very extreme crimes and misconduct, then you lost your ability to take mainstream insurance, to work at a hospital, to work in a practice group. What were you going to do? Well, maybe you'd be able to get a job at a prison. You could hang a shingle and sell prescriptions, cash-based medicine. You could work in a rural area. Basically, you could work with the very most vulnerable populations of patients. There is evidence that something very similar is happening in law. The slaps on the wrist that the self-regulatory system is delivering result in lawyers that are less likely to keep their job at a big firm where they might at least be supervised and have colleagues, and pushes them into that solo practice where you're working with vulnerable populations. Maybe you're doing appointed work for criminal cases. Maybe you're working in immigration. Maybe you're working in personal injury. But also now you're kind of in a cash-based system where you have to turn over a lot of clients. You have to work volume. And so now the temptation to cut corners is even stronger. So I think the evidence on this is preliminary. I think we need to know more about how this faulty disciplinary system is affecting the provision of legal services and in some way making the access to justice problem a lot worse. But I think that there's some evidence that supports the idea that the same thing is happening in law that I observed in medicine.
Thanks so much, Rebecca. I think it's so important for us to the big question of like these assumptions that non-lawyer and non-licensed providers are going to harm individuals. We do not have a justification that individuals already in the profession are not harming individuals, or at least we don't have good data. So I completely agree that more inquiry is needed on that question. Lauren, I saw you vigorously nodding your head, so I will turn it to you next, and then Allison will finish off with you. Really quickly before we begin, if you do have questions for our panelists, we'll probably have time for one or two. So please feel free to drop those in the chat now, and we'll get them queued up. So back to you, Lauren.
I'll just note those were such good points, and I think it's so important that yes, like the the probationary doctors and lawyers, they're going to rural America, they're going to Indian country. There's this disproportionate exposure, and so like I totally endorse that the regulatory arm of these bodies are at best like not fulfilling the objective, but I think as Rebecca notes, they likely are fulfilling their objective. It's just that that objective is not meaningful to the people, to the communities that they're serving. I'd note that like part of this too in Indian country, I think tribal courts are actually have a unique advantage here because so few law schools, and this is changing, but so few law schools have any meaningful Indian law or tribal law. It's probable that most barred attorneys have no idea what tribes are, what tribal courts are, or much less what the expectations are. Not meeting the basic competency requirements. It's clear that they don't understand sources of law. They don't understand what is binding authority versus persuasive authority within the tribe. And so it means that tribes are able to quickly identify like this isn't actually meeting our basic needs of competence in ways that a lay advocate might. And so it just means that we get to modify our criterias on the fly, both because we have to, but we also have the advantage of being able to more quickly identify your shortcomings based on an education criteria that was not crafted or even had us in mind.
Thanks so much, Lauren. And Allison, finally to you, your thoughts on this question.
So maybe I'll come at it from a different angle than what we've been talking about, which is one of the things people often presume is that having more money, like federal funding, or lifting restrictions on corporate practice, or both of those things together, will lead to more innovation and better results. And one of the things I talk about in my chapter is that that's definitely not a given. It has to be done very carefully if it's going to lead to good results. So if we look at what happened in the medicine space, you have the combination of this physician monopoly with a financing system that is flush with money but disorganized and not, and not always regulated towards the right ends with Medicare and Medicaid. And then you see a lesser enforcement of the corporate practice laws, and you get corporatization and financialization. So you get money coming in, but what it's producing is not really what we want to produce at the end of the day. We have a system now where most doctors and other practitioners are employed. More and more, they're being employed by corporate groups like United Healthcare, which employs 5% of doctors now. We see private equity buying up physician practices and health care organizations like staffing services. And what is it producing? From the early evidence, what we see it's producing is worse outcomes and higher spending on medical care. 70% of people feel like the healthcare system is failing to meet their needs in an important way. and the US system falls further behind peers. It started far behind, and it falls further behind in important things like life expectancy and infant mortality. And so, why is this happening? Well, regulators are a step behind sophisticated financial players. They haven't figured out how to enable outside dollars to come in, yet prevent this kind of corporate gutting of medicine in the name of profit. And so one of the things I really talk about in my chapter is if in law, if we think about things like, lifting restrictions on outside dollars coming in and trying to create more funding sources, we have to do that really carefully in order to preserve quality and to create the kinds of good outcomes and representation as we expand access.
Thanks so much to the four of you. We have a little bit of time left, so I'm going to ask kind of an amalgamation of a few questions that we've received in the chat, and just do kind of a quick round robin on, and then this is the question for the round robin, and try to keep your answers to, a few sentences, and we'll see. Hopefully we can get around to everyone. But you've all provided such valuable kind of insight from, again, other places, other industries, other jurisdictions. What do you think, if you could say, this is the key lesson that the legal profession should learn from these other places, industries, jurisdiction? What is that lesson for regulators, for stakeholders, for members of the legal profession? Let's go in maybe reverse order this time. Allison, let's start with you.
I think the key lesson is that there's an opportunity without kind of opening the floodgates to think about how to expand practice and meet more people's needs. And I look back in medicine and I wonder if doctors hadn't held so tightly to kind of control of the profession and to who can do what, and if they had earlier developed with kind of in conversation a more capacious vision of how different people could practice and meet people's needs, I think it could have headed off a lot of the problems we're seeing now. It may be too late in law to do that, but if it's not, like that's one of the things I think about when I'm in these conversations is there's still the time and the space to think more broadly and capaciously about how to meet legal needs so that, we don't end up with kind of a corporate ownership of a very expensive system.
Thanks so much, Allison. Lauren, let's turn it to you.
Well, I'm struck by the need for accountability, but the need for meaningful local accountability. And so I think that recognizing that in this case, lawyers are not in and of themselves critical, but are actually serving a role in a much larger like system and community, and be having a little humility about what their contributions are and what their limitations are might serve. But I think for tribes, it means that for good and for bad, the onus is on tribes, that the regulation is not going to be self-executing. It's upon ourselves to do that regulation ourselves.
Thank you so much, Lauren. Rebecca. Still muted. Rebecca, you're muted. Thank you.
It's actually great because I said nothing interesting whatsoever. But here I'll start now. I think that medicine actually maybe it's a cautionary tale in some ways, but I think that there's some things that we can learn from medicine that actually are good. And that is that this idea of not all medical services now are provided by doctors. And I think the introduction of nurses and nurse practitioners and physician assistants and everything down kind of the chain of, I don't, I'm using the word down, and that's kind of like a little bit unfair, but I do think there's sort of a social hierarchy and a status question there where that word is appropriate. We don't have to think about it that way. We can think about it as specialization. But right now, law is so monolithic that I think we're missing out on a lot of expansion of access to care by not allowing other kinds of providers, even maybe licensed providers, like what we have it with nursing and, what nursing is to medicine, something that law could use to expand access.
Thanks so much, Rebecca. And finally, to Juliet.
Well, picking up on one of the things that came up in the questions, with choice and diversity in the market, including across regulated and unregulated individuals and services, one thing that's key is, I think, transparency, consumer education and information, so people understand what they're buying and who from. I think for regulators, I'd say watch out for the unintended consequences of putting up barriers. It's easier than you think for workarounds and for the market to just move in the way that it's going to move, and regulation, bringing those arrangements within the regulatory tent means that you can put in place safeguards, you can monitor impacts, you can leverage the benefits. And finally, I would just say allowing direct investment in law firms allows kind of investment in technologies, investment in innovation that really can kind of help to drive forward consumer choice and access to justice.
Thank you so much. Thanks so much. A round of applause, a silent round of applause for our four panelists. You've offered such valuable insights here as the legal profession kind of enters its next phase. So please join us for our fourth and final panel. We've dropped a link in the chat to register. It will be held on June 24th at 10 a.m. Pacific. And thank you all so much for attending. We really appreciate you giving up part of your day to hear from our panelists and learn from their very valuable expertise. So thank you so much.